Well, hello everyone, and welcome back to part 2 of our Chapter 6 lecture on searches and seizure of property and search warrants. So we left off, we had finished talking about the Chamel case and the search incident to an arrest. We know what that means and we know what that is now. But now we want to talk a little bit about this thing called the contemporaneous requirement. So a search incident to an arrest is required to be contemporaneous with that arrest. And this means that the search must be undertaken immediately before the arrest, at the same time of the arrest, or immediately after or following the arrest. And what do you believe might be some reasons for the requirement? I'll just kind of let that question hang out there for a second, because there are some important rationales on why that should be there. Okay, so a couple of quick cases to kind of help you answer the question. So Rawlings versus Kentucky in 1980. This case basically held that the search must be undertaken immediately before the arrest, at the same time as the arrest, or immediately following the arrest. And again, we asked what the rationale is for that. Well, when we ask what the reason for the requirement would be, is it would really make no sense to delay the search and give the suspect the opportunity to either destroy evidence or use a weapon against an officer, right? So the Supreme Court accordingly has held that a search that is remote in time and place fails to meet that test of reasonableness under the Fourth Amendment. So there are some reasons why we need to do that. Now, in another case, in the arrest at issue in this case, Preston versus United States, here 3 individuals were sitting in a car at 3 a.m. in a business district of Newport, Kentucky. They were arrested for vagrancy, and the car was driven to the police station and searched, resulting in the seizure of 2 firearms. And a second search led to the discovery of objects that were clearly meant to be used during a robbery. Now, one of the detainees in this case admitted that the men planned to rob a bank. So the U.S. Supreme Court held that the justifications for searches incident to arrest are absent when a search is remote in time or place from the arrest. So once an accused is under arrest and in custody, then a search made at another place without a warrant isn't considered to be incident to arrest. So that's kind of an interesting case, right? So here they found the evidence showing that these individuals were going to commit a bank robbery, but again, after they placed the individuals under arrest, that search of the vehicle was done at a different place without a warrant. Now, they could have got a warrant, which would have made everything okay, but in this case, that did not happen. So, again, kind of interesting. And in the case, the court noted that at the time the car was searched, there was no danger that any of the men arrested could have used any type of weapon, or they could have destroyed any type of evidence relating to the crime. So that's the rationale. So an interesting case, Preston versus United States. And in another case, United States versus Edwards, it's viewed as a significant exception to the contemporaneous requirement. So in Edwards, the U.S. Supreme Court upheld the warrantless search and seizure of paint chips from Edwards' clothing 10 days after he arrived at the jail as a normal incident to arrest. So again, United States versus Edwards, kind of, effects in the suspect's immediate possession may be searched on the spot at the time of the arrest or later when the accused arrives at the place of detention. So that's kind of a super interesting case, right? So they found these paint chips on his clothing 10 days after he arrived at the jail as a normal incident to arrest. Now here again, the court held that the effects in Edwards' immediate possession may be searched again on the spot at the time of arrest or later when the accused came to the place of detention if need be. So again, just a very interesting viewpoint from the court on that. So another case that's important for us to know is the New York versus Belton case. And now we're going to kind of look at a little bit of searches of the area similar to Schimmel, but when we're talking about automobiles. So this is more discussion on immediate control searches and vehicles. So in 1981, New York versus Belton, the U.S. Supreme Court defined the scope of a search incident to an arrest of a person in a vehicle. Schimmel did it for a car, but now here we're talking about a vehicle. So the court applied that same precedent, and we've talked about what precedent means, right? It's where the justices will look at cases that are similar when they're trying to decide matters of constitutionality in cases that they're currently dealing with. So here the court applied that same principle in Schimmel, holding that articles and containers within the passenger compartment as a rule are within an area in which an individual might reach in order to grab a weapon or some item of evidence. So hopefully that kind of makes sense, right? So in this particular case, just to give you a quick summary, here an agent by the name of Douglas Nycott pulled over a vehicle for speeding on the New York State thoroughfare, and Officer Nycott smelled burnt marijuana and saw an envelope marked Super Gold, which is a brand of marijuana, on the floorboard of the car. So because of that, he ordered the driver and passengers out of the car and placed them under arrest. Now, Officer Nycott then searched the passenger compartment and found a black leather jacket belonging to Belton, the driver. And Nycott unzipped one of the pockets and discovered cocaine, and Belton was subsequently charged with criminal possession of a controlled substance. So the question before the court in this case was the lawfulness of the seizure of cocaine. Does that kind of make sense? So again, here in this case, Justice Stewart applied the precedent in Schimmel and held that the articles within the passenger compartment as a rule are within the area in which an individual might reach or in order to grab a weapon or some type of item of evidence. Now, the court accordingly held that when officers make lawful custodial arrests of individuals in vehicles, they may, as a contemporaneous incident of that arrest, search the passenger compartment of that automobile. So again, this is one application of this particular case, but we'll see a little bit more in a couple of different cases. Now, another case, or another couple of cases that are really important, would be the Thornton versus United States case and the Arizona versus Gant case. So in the Thornton versus United States case, the Belton case applies to recent occupants who have exited a vehicle. So again, kind of an interesting case where someone had just recently exited the vehicle. Now, the next case, the Arizona versus Gant case, is a little bit different. Here, Belton does not authorize a vehicle search incident to a recent occupant's arrest after the arrestee has been secured and cannot access the interior of the vehicle. So here you have a case where things have kind of modified a little bit, where a person recently may have exited the vehicle, but then you end up arresting the person and you put them in the back of your, say, patrol vehicle. So here what they're saying is that after the arrestee has been secured and they cannot access the interior of the vehicle, then the fear factor or even the destructive factor of evidence kind of goes away. Does that make, hopefully that kind of makes sense to everybody. So the case of Arizona versus Gant is located on page 183. And basically the issue is after Mr. Gant was arrested for driving with a suspended license, handcuffed and locked in the back of a patrol car, police officers then searched his car and discovered cocaine in the pocket of a jacket on the back seat. And in this case, remember, Gant could not have accessed his car to retrieve weapons or evidence at the time of the search. So again, here the court had to consider whether the Arizona Supreme Court was correct in holding that the search incident to arrest exception to the Fourth Amendment's warrant requirement, as defined in Schimmel versus California, applied to vehicle searches. You know, and kind of looking back at the New York versus Belton case, you know, did it justify the search or not? And I'll let you kind of do a little bit more research on that. So again, a lot of information, a lot of different ways that these searches can go, but we've been talking primarily about felonies, those higher type crimes, if you will, more severe crimes. But what about misdemeanors? This is a little bit different. So may the police conduct a search incident to an arrest for a minor misdemeanor, such as, say, DUI or something different, or driving on a suspended driver's license. So a lot of kind of interesting thoughts there. So there is no requirement that the officer reasonably believe that the suspect is armed and dangerous when you're talking about a search incident to an arrest. There is no requirement that the officer reasonably believe that an offense for which the suspect is arrested is associated with the possession of weapons, or that there is a risk that evidence may be concealed or destroyed. The Supreme Court decisions in this particular case I'm going to talk about, in Robinson and Gustavon, established what we call the bright line rule. The fact of any arrest authorizes a search of an individual regardless of the offense. Does that make sense? So anytime that someone has been arrested, they are subject to search. Now, why is that good? And I know these are a couple of different cases here. So quickly. In the incident at issue in the U.S. versus Robinson case, an officer by the name of Jenks stopped Robinson for operating a motor vehicle after his license had been revoked. And the officer arrested Robinson and then conducted a search incident to arrest. And during the search, the officer discovered a crumbled up cigarette package that contained heroin. So Robinson contended that the search of his person was unlawful because there was no indication that the officer believed that there was evidence associated with the offense of driving without a license that might be destroyed. So again, kind of an interesting thing here. But the court held in this case that custodial arrest, gives the officer the right, regardless of what information they have or don't have, to conduct a search. Now, in comparison, the case of Gustafson versus Florida, the Supreme Court upheld the lawfulness of an officer's arrest and full search of Gustafson for driving without a license. And the Supreme Court noted that Florida law provides a police officer with discretion to arrest the suspect or to issue a ticket. And here the court relied on the precedent established in Robinson and noted that the fact of the arrest that provided justification to search Gustafson, despite the fact that the officer did not fear that he was armed and that there was no basis for believing the officer would uncover incriminating evidence, it kind of didn't matter. So the Supreme Court decisions in both Robinson and Gustafson established the bright line rule. The fact of an arrest authorizes a search incident to an arrest regardless of the offense for which a suspect is arrested. And why do you think they came up with that? Why do you think they established this bright line rule? Well, the reason, there's a couple of reasons. First would be judicial review. One is the fact that the courts really don't have enough time to review the reasonableness of every single search incident to arrest. So again, we're backing up and saying, if I arrest you for having a suspended license, but I search you and find a gun, I didn't know you had a gun. I had no inkling that you were carrying a gun, but yet I found it. So should that be thrown out? So something to think about. Number two would be safety. And searches incident to an arrest protect the safety of officers, because a simple frisk does not fully safeguard the police, and that makes sense. Next would be evidence. Searches incident to an arrest may result in the seizure of evidence of other crimes, kind of like in the example that we just talked about in the Gustafson case. And then finally, privacy. A search is a modest intrusion on an individual who, once having been subjected to an arrest, has already lost a degree of personal privacy. But then there are some other interesting things, right? So there's a case out there, Knowles versus Iowa. And here's, this totally makes sense, and I think everybody will go along with this, but in Knowles versus Iowa, an officer pulled over Mr. Knowles for speeding. The arresting officer under Iowa law is provided with the discretion to issue a citation or to arrest an individual stopped for speeding, in either instance to conduct a search incident to an arrest. And the officer issued, in this case, Mr. Knowles a citation and carried out a search of the automobile that resulted in the seizure of a bag of marijuana and a pipe. And the U.S. Supreme Court held that the two historical rationales for search incident to an arrest exception were not sufficient to justify the search of Mr. Knowles' automobile contemporaneous with getting a ticket. Does that, and hopefully that makes sense. So if you're under arrest or if you're given a citation, we can't go into your car. And this is one of those interesting cases that talks about searching a vehicle incident to citation. So hopefully that kind of makes sense as well. Okay, a little bit more about this thing called the bright line rule, because it is important that we understand this. And again, when we talk about that citation case, the Knowles versus Iowa case, just finally the court recognized that officer safety is both a legitimate and weighty concern. Again, however, the threat to officer safety stemming from the issuance of a traffic citation is a lot less than in the case of an actual custodial arrest, because a custodial arrest involves danger to an officer because of the extended exposure that follows the taking of a person into custody and subsequently transporting that person to the police station, along with the associated stress and anxiety associated with an arrest. Okay, so enough of that, but let's move on to a couple of quick comments about the bright line rule. So the bright line rule is a clearly defined rule or standard composed of objective factors which leaves little or no room for interpretation. And the purpose of the bright line rule is to produce predictable and consistent results in its actual application and interpretation. Okay, so a couple more sections. The next one we're going to talk about really quick is going to be something that we call pretext stops. And there's actually even a pretext arrest. So in the United States versus Robinson case, this case discussed, again, Officer Jenks pulled Robinson over based on a prior investigation that indicated that Robinson was driving with a revoked license. And because of that, a pat-down led to the seizure of heroin. And Robinson alleged that the officer was aware that he had 2 prior drug arrests and had used the traffic stop as what we call a pretext arrest to enable the officer to search for unlawful narcotics. Now, the Supreme Court in this case did not address Robinson's contention that the officer had engaged in a pretext arrest, and in a footnote merely observed that the defendant, Robinson, had been lawfully arrested for the offense. Now, 23 years later, in another case called Wren versus United States, the U.S. Supreme Court basically answered the question of whether a defendant may raise the defense that his or her seizure is the product of a pretext arrest or a pretext stop, and whether any item seized pursuant to the resulting search would be excluded from evidence. So the case at issue in Wren was Michael Wren and James Brown were stopped in Brown's truck for 3 traffic violations in a high drug area in Washington, D.C. by plainclothes officers. They were vice and narcotics officers. And as they approached the vehicle, the officers observed 2 bags of crack cocaine in the truck, and they arrested both Wren and Brown. And the 2 arrestees conceded that there was probable cause to stop them. However, they alleged that the traffic stop was a pretext to investigate their suspected narcotics activity. And they also suggested that they had been singled out because they were African American. Wren and Brown pointed out that police regulations stated that plainclothes vice and narcotics officers were to make traffic arrests only in situations posing a threat to public safety. So an interesting thing. So can you make a stop on a vehicle, let's say a lawful stop, when your intent is to maybe get into the car and search it because maybe you know they're drug dealers or you've arrested them before, but all you have is they were speeding. So it's a legitimate reason for the stop. So super interesting case. So in this particular instance, the Supreme Court held that a police officer may arrest the driver of a car based on probable cause, again, and that's okay, we need probable cause to arrest, that the driver is violating the law, and may then conduct a search incident to an arrest. And it also continued and said that the officer's subjective motivation, meaning why they, whatever their other reason is, plays no part in the Fourth Amendment analysis and does not make an otherwise lawful stop or conduct illegal or unconstitutional. Does that make sense? So if I stop you for a reason, okay, like in this case, let's say that you're speeding, but I know my rationale is to somehow get into the car and find some drugs or something like that, and I have probable cause to arrest you, even though my motivation was something else, is it really constitutional? So here, the pretext stop was held to be valid because the subjective motivations of an individual, it doesn't really matter. So why does the court hold then that an officer's subjective intention should not be considered in evaluating the reasonableness of an arrest or a search? And why do you think that is? And just kind of give you a second to kind of talk about it. I mean, when you look at some different types of searches out there, so to answer the question a little bit before we move on to a couple of other things, again, in this particular case, the Supreme Court held that a police officer may arrest the driver of a vehicle based on probable cause, that the driver is violating the law, and then may conduct a search incident to the arrest. We know that the officer's motivations play no part in that Fourth Amendment. And the court did stress that the U.S. Constitution prohibits selective enforcement of the law based on considerations such as race, but the basis for objecting to the intentionally discriminatory application of laws is the Equal Protection Clause rather than the Fourth Amendment. So again, in reading United States versus Wren and looking at it, ask yourself whether, Wren and Brown were stopped on a pretext arrest and whether you agree with the Supreme Court's decision. And was it reasonable or was it not? And if you want to learn a little bit more about the case, because we know what the issue is, it's on page 190 in your textbook. Okay, so a couple of other types of searches. Remember at the beginning we talked about we would cover a few other searches that really are kind of interesting or different. And the first would be consent searches. So in another case, Schneckloth, I know some of these names are crazy, huh? Versus Bustamante, 1973, the U.S. Supreme Court held that a consent search is a reasonable Fourth Amendment search. And an individual who consents to a search waives his or her right to privacy under the Fourth Amendment. And I have a link to the case there if you want to look at it. So also, this provides legal authorization for the police to conduct a search even in those cases in which the police do not have a legal basis to search a person or a container, home, or automobile. So again, consent can kind of override something that, the officer doesn't really have the basis to conduct the search, but they can ask for consent. Now, the Supreme Court noted that consent searches are part of the standard investigatory technique of law enforcement agencies, and that consent in many cases may be the only means of obtaining important and reliable information. But we have to keep this in mind. The same case, the Schlecknoff case, held that the legal test for a consent search is that the consent must be voluntary and may not be the result of duress or coercion, or be express or implied. And voluntariness is to be determined by the totality of circumstances and the fact that an individual is aware of the right to refuse consent is one of those factors to be taken into consideration. So the Supreme Court noted that this voluntary test balances the need for the police to conduct consent searches because it is an investigative tool against the need to ensure that consent is freely given and is not the result of duress or coercion. So to pass constitutional muster, again, consent must be voluntary and may not be the result of duress or coercion. And the officers, they don't have to inform the suspect of the right to refuse consent. And one other interesting thing is that the burden of proof is on the prosecution to establish the voluntariness by which a preponderance of the evidence, the 51%, shows that voluntary search was approved or accepted by the defendant. So there really is no single factor that determines voluntariness, but there are several factors. So in evaluating levels of voluntariness, the courts are going to look at a bunch of different factors. So they're going to look at what we call the totality of the circumstances. They're going to look at a lot of different things. And in there, here are some of the things that fall under the totality of circumstances. One would be coercive police procedures, whether or not there was some type of psychological pressure or a police-dominated atmosphere that might coerce somebody. Custody, whether an individual is in custody or physically restrained or handcuffed when they are requested to consent to a search. Does that make sense? An individual who voluntarily turns himself in to the police is more likely to have voluntarily cooperated to the police and have freely consented to a search, where someone who might be in custody, handcuffed, etc., may not be. Aware of their right to refuse, meaning whether a person is informed of his or her right to refuse consent. And again, you don't have to tell people, basically, but whether or not they were aware of the right to refuse, that's something that's going to be looked at. Request for consent, whether there are a number of requests before somebody finally agrees. You kind of physically wear them down and they finally agree. Experience in the criminal justice system. An individual who has experience in the criminal justice system is less likely to be tricked or coerced than someone who is not. A consent to search form. Many police departments now provide individuals with a form to sign that indicates that they consent to search. Did the defendant sign or refuse to sign the form? Miranda warning. Individuals in custody who are read the Miranda warnings are informed that they are not required to submit to police interrogation. And in many cases, when asked to consent to a search, they also are informed that any object seized during a consent search may be used against them. So an individual who receives a warning might be less likely to have been willing or coerced to sign a waiver. And then finally, the seizure of contraband. Defendants in several cases have argued that their consent could not have been voluntary because the police found incriminating evidence in the course of that consent search. Now, courts, however, have generally held that the fact that an object of the search is well hidden may indicate that the individual consented because he or she did not expect that the officers would actually find it. So these are some of the circumstances in evaluating the voluntariness, and the courts will actually look at that. And a couple of other cases, the Florida versus Hamino case. The Supreme Court has held that objective reasonableness is the standard for measuring the scope of consent to search. What would the typical reasonable person have understood by the exchange between the officer and the suspect? And another case, United States versus Dicarante. And this is where a consent search is reasonable only if kept within the bounds of actual consent. The defendant's consent will set the parameters of the officer's conduct. And then understand that a person can basically limit your searching or stop your search as it relates to consent at any time. So they can tell you, you can only search here, I consent to that, but you can't search there. Or you could be searching under consent and the person could say, stop, I don't want you to search anymore. So understand that those are applied as well. So what are some things that are not voluntary consent? Because in order to, you have to consider some of these situations in which courts have held that the defendant did not voluntarily consent. So one would be lack of consent. Can I search your vehicle? Hey, I got nothing to hide. That's not voluntary consent, right? It really didn't say yes or no. So you have to kind of think of that. What about mental disability? So that's something that needs to be thought of as well. Threats to get a warrant, like empty threats. And, kind of like the no other alternative. So threats to get a warrant. So again, that's not a voluntary consent, of course. Coercion. If you don't consent, I'm going to take your kids away and take them to CPS. Or even trickery. Maybe posing as a gas employee to gain entry. All of these are not voluntary consent. Okay, so hopefully that all kind of makes sense. And there's a list of those items again on chapter 196 in your textbook. We talked a little bit about withdrawal. Again, an individual can withdraw their consent or limit the scope at any time. A withdrawal of consent does not affect the items that you've already seized. So if you already have something, that still counts, or you could still use it. And the courts do require a clear, unambiguous, and unequivocal act or statement of withdrawal. So there needs to be something very, very clear on the defendant's part. And what about third party? We're not going to go over a lot of third party, but understand, especially in this case, Frazier versus Cupp. The Supreme Court held here in this case that Frazier by leaving his duffel bag at his cousin's house and allowing his cousin joint use of the bag basically meant that he assumed the risk and the hope that the cousin wouldn't allow someone to look inside. So third-party consent can sometimes be tough, but if there's something jointly used, you assume the risk that that person won't allow somebody else to look. A couple of other cases, Illinois versus Rodriguez. Here, the Supreme Court established the legal standard for third-party consent searches, and the police may obtain consent from a person that they believe has common authority. So again, common authority third party requires mutual use of the property by persons. They have joint access or joint control for most purposes. And then apparent authority third party means that police, again, reasonably believe that a person has common authority. So if the officer knocks on the door and they talk to someone that lives there, and they say that, they say they live there, they say that they pay the rent, they do all this stuff, and there's apparent authority over the area, law enforcement, if they believe that they have common authority over that area, then it's okay even if they don't. And I put in a little chart because it's so confusing. So here's to kind of give you an example, and this is in your textbook as well, but this talks about the relationship and the authority to consent. So you have wife, husband, parent, child, motel, landlord, employee, etc., and even roommates. And then kind of the legal equation, even though that other chart might be a little bit more helpful when it talks to consent search. Here's the legal equation. And then again, finishing up, here's the third party legal equation. And then finally, we're going to wrap up with what we call we're going to talk about probable cause and automobile searches. So we talked about the scope of a consent search, withdrawal of a consent. We went over basically third-party consent, not in super detail, but enough to where I hope you have a good understanding. And now we want to talk about probable cause in motor vehicles. So we have seen that a search incident to an arrest may permit the search of a passenger compartment of a vehicle. Police may also conduct a consent search of a vehicle, but there's a third type of warrantless search of a vehicle, and this is the automobile exception. So the automobile exception to the Fourth Amendment permits the police to conduct a warrantless search of vehicles where there is probable cause to believe that the vehicle contains contraband or evidence related to criminal activity. Now, it's not just a fluke, it's not reasonable suspicion, it's probable cause. Remember, that's what you need to arrest or search. So, the U.S. Supreme Court first established the automobile exception in 1925 in a case called Carroll versus United States. And I've got a link to a video and also to the case itself if you want to look at it. But the automobile exception to the Fourth Amendment, again, permits the warrantless search of a vehicle where there is probable cause to believe that the vehicle contains contraband or evidence to a crime. And the court held in this case that it is not practicable or practical to require the police to obtain a search warrant for motor vehicles most of the times, pretty specifically due to their inherent mobility. So again, kind of an interesting type situation, right? So the U.S. Supreme Court observed that the Fourth Amendment freedom from unreasonable search and seizure historically has been interpreted to distinguish between search of a store, a dwelling, a house, or other structure in respect of what a proper official warrant would be based on, probable cause, etc. And even a search of a ship or a motorboat or a wagon or an automobile may be searched on probable cause without a warrant. So, the court again explained that it's not practical, if you will, to require the police to get a warrant for motor vehicles because the mobility of the automobile might result in the vehicle disappearing down the highway by the time that a warrant is actually obtained. So a lot of information in this particular case. And along with that, and maybe a little bit more, the explanation in Carroll, again, is that the mobility of automobiles makes it impractical to require the police to get a warrant, again, in each and every, because it doesn't fit every single situation. Consider a case in which the police stop, seize, and immediately immobilize a motor vehicle and transport the car to the police station. The police, once having taken the vehicle into custody, could easily obtain a warrant. So that's another kind of thought process. So, again, when the police have probable cause to believe that there's contraband in the vehicle, that they may conduct the warrantless search of the vehicle, okay? And if they choose to impound it and get a search warrant, then they can do that as well. And another case in 1985, California versus Carney, the U.S. Supreme Court held that the automobile exception is based on the mobility and less expectation of privacy. And there are two justifications, again, for the warrantless searches of motor vehicles. And the first one is mobility. The motor vehicle is obviously readily mobile by the turn of a switch or a push of a button nowadays. And the next regulation, there is a reduced expectation of privacy in a vehicle because the vehicle is subject to a range of police regulation inapplicable to a fixed dwelling. And this includes things like a license to drive, or vehicle registration, and safety and environmental regulations. And the Supreme Court in other cases have held that motor vehicles have a reduced expectation of privacy based on the fact that vehicles travel on public highways. The exterior and interior of vehicles is easily observed by a plain view search, and people rarely store personal belongings in their cars. So kind of an interesting thought, right? As we look at some of these different things. So look at California versus Carney, and kind of think about that. Are vehicles, can they be considered homes? Ooh, what about a motor home? Okay, I hate to take up too much more time, and it looks like we're going to have two long lectures here, but an interesting case. The Supreme Court in Carney actually rejected the argument that the fact a motorhome is capable of functioning as a home provides the vehicle with a heightened degree of privacy and requires the police to obtain a search warrant. The court reasoned that the motorhome in Carney was readily mobile and was clearly being used as a mode of transportation. And the Supreme Court indicated that a warrant might be required where a motorhome is situated in a way or place that objectively indicates that it's being used as a residence. So a little bit of a gray area there between those two things. So what about containers in vehicles? Well, the Supreme Court has held that individuals retain a reasonable expectation of privacy in enclosed containers. A container is described as any object capable of holding something else or another object. It could be luggage, it could be a book bag, it could be a knapsack, a box, a paper bag, or even a little jar. And the Supreme Court has struggled with the question of whether a warrant is required to open containers encountered during the search of a vehicle. And in some instances, it's very clear a warrant is required to open things. So clearly, a warrant is required to open, let's say, luggage that is seized outside of a car, but what about something smaller? Does it make sense for luggage to lose its expectation of privacy because it's inside the car? So again, a super interesting thing when you look at that. So the U.S. Supreme Court has held that individuals retain a reasonable expectation of privacy in enclosed containers. And again, a container is any object capable of holding another object. And we know, as I said a minute ago, that the Supreme Court has struggled with that question of whether a warrant is required to open containers encountered during the search of a vehicle. And clearly, again, a warrant would be needed to open luggage that is outside of a vehicle. But does it make sense for luggage to lose its expectation of privacy because it's inside the vehicle? And the Supreme Court's internal debate over this question has taken a number of twists and turns over the years. And the judges now have settled on the sensible rule that a container inside of the automobile may be searched without a warrant when there is probable cause to believe that the container houses the object of the search. Does that make sense? So probable cause limited to the container, and you can search the container but nothing else if you have PC to believe that whatever evidence you're looking for is in that container. Okay? And probable cause extends to the vehicle, which means you can search the entire vehicle and open containers. So again, kind of an interesting thing. So let's look at these two things here. So probable cause limited to the container. The police have probable cause to believe that there is contraband or criminal evidence inside of a container that's within a vehicle. The police have probable cause to seize and search the item, and it does not require a warrant. What about probable cause that extends to the vehicle? The police have probable cause to believe that there are narcotics somewhere within a motor vehicle. They therefore may search the entire vehicle for narcotics and open without a warrant any containers that may house the narcotics. So again, some difference of opinion, some gray lines in there, but I tried to clear it up for you. Here is basically the legal equation. We talk about probable cause and other items. A couple of other things, just really quick. Plain view. Again, in order to seize an item, the officer, if they see it plain view, they must be able to recognize the item as being illegal. We've gone over the Terry versus Ohio case. The police may conduct a frisk of an individual subjected to a reasonable suspicion stop for dangerous weapons, etc. And then finally, emergency circumstances. The police may enter a dwelling without a warrant to prevent the destruction of evidence or in hot pursuit of a fleeing suspect or in response to a threat to public safety. And the scope of that warrantless emergency circumstance is defined by the object. Okay. And then finally is inventory, and then we're going to be done. Police record all of the possessions and clothes that are with an arrestee at the time that he or she is detained and arrested, including objects inside of an automobile. And there are basically purposes for that. 4 purposes: false claims, to identify the property for safety, and of course for identification. So, we don't want to have the false claims. We want to deter false claims, so we do an inventory. Property, to protect the property against theft. We want to make sure that we inventory. Safety, to prevent the arrestee from injuring themselves by keeping like a knife in their pocket or something like that. So that's why we inventory. And then identification, of course, to confirm that the individual's identity or ascertain the individual's identity. And then we have a little bit on the legal equation for this as well. Okay, in the future, interesting things is, what if we didn't need a search warrant to read, or have to read you your rights to get a statement? What if we could just hook you up to a machine and read your mind? So this is a video to a cool little interesting thing on being able to read somebody's mind, and could we use that later at some time for probable cause. Super cool, super interesting, and we're super done. And I know those were 2 long halves, but there's a lot to cover as it relates to search and seizure. So that will conclude part 2 of our chapter 6 lecture on search and seizure of property and search warrants. So until next time.